Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about the independence of Canada's prosecutors from political interference. Recently, the CBC reported that political staffers in Alberta Premier Danielle Smith's office had pressured Crown prosecutors on cases stemming from COVID protests that had blocked the border in Coutts, Alberta. Smith and her staff deny pressuring Crown prosecutors, and an internal scan of 1 million emails found no evidence that staff had contacted Crowns about charges related to the Coutts blockade. However, Smith had previously made statements that she had, to quote, put it to prosecutors and asked them to do a review of cases related to public health order prosecutions. She has now said that she has at no time communicated with Crowns and that her language was imprecise. What exactly does prosecutorial independence mean, and what exactly would constitute political interference in that independence? Here today to discuss this issue are two legal experts, law professor Steven Penney and political science professor Lori Williams. Thank you both so much for joining me today. Professor Williams, I've described what happened in this case, in this Danielle Smith case. Is there anything more in the background that you think we need to know about what happened?
Well, I think it's probably helpful to know that Danielle Smith wrote a column about the SNC-Lavalin matter and the pressure that she saw being exerted by the Prime Minister's office on Jody Wilson-Raybould. And she lamented in her column that nobody had found or provided evidence of criminal obstruction of justice. So it's, I think, important to understand that the standard that we're talking about today is one that she was very strong about imposing on the Prime Minister's office in the SNC-Lavalin case.
Yeah, so let's remind our viewers, Professor Penney, what happened in that SNC-Lavalin case, because that also, there's a parallel here. This is a case that also allegedly involved interference, political interference in prosecutorial discretion.
Yeah, basically what happened there, so far as we can discern, is that pressure was applied by Prime Minister Trudeau and members of his staff in the Prime Minister's office to Jody Wilson-Raybould, who was then Minister of Justice and Attorney General, and therefore had overarching responsibility for the prosecution of this Quebec-based multinational firm that had been charged with basically bribery and corruption under Canadian law. And the concerns expressed basically amounted to, you should try to find a deal, because if you apply the law and end up prosecuting and having this company convicted, it could result in job losses and the economy of Quebec could suffer. And there was also suggestion that the political fortunes of the Liberal Party in Quebec could potentially suffer as a result of this prosecution. Ultimately, Minister Wilson-Raybould refused to buckle under that pressure, and she ended up resigning from the government.
Steven, do you see a parallel between that situation and this current one with Danielle Smith?
Sure, at least at a high level, there's a potential parallel. Now, we don't know all the facts. We haven't received any definitive sort of ruling or finding on whether there was contact between staff in the Premier's office or the Premier herself and any frontline Crown prosecutors, nor are we aware of the precise content, as far as I know, of any communications that may have occurred between the Attorney General and Minister of Justice here in Alberta and the Premier. But assuming, just hypothetically, that pressure was placed on the Attorney General or on individual prosecutors down the line to, stop these prosecutions or consider alternative measures or whatever it may have been, then you do potentially have a parallel with what happened at the federal level recently.
Now, Professor Williams, what's your reaction to the internal investigation that has taken place so far? It was an investigation of these emails. Should we be satisfied by that? I mean, it's only addressing emails, not additional communications. And if it's internal, is that sufficient?
Well, and that's part of the problem. It's not seen as a completely independent investigation, even though it was an independent civil service review. The bigger problem, I think, is that it only investigated or only had access to deleted emails back to December 22nd, and the alleged emails were sent in November. So if they had been deleted, then obviously the investigation would not have found them. The other thing is that it does not appear to have reviewed personal emails. So if there was a communication on a non-governmental email account, that wouldn't have been covered by this investigation. So in the past, when questions like this have been raised, there has been an independent inquiry involving, let's say, a retired justice or something like that.
We've got to go to break, but we'll be right back.